Hello, so we've been looking at the tort of negligence, and the first strand of identifying negligence is by showing that the defendant owed the claimant a duty of care. Now, this is not always done by looking at existing precedent, as that was established through Donoghue and Stevenson, or through the incremental test in Caparo, threefold test in Caparo. Sometimes there are other types of law which impose duties. An example of this is where you are the occupier of a land and some kind of personal injury or damage has taken place on your land, you may be held liable. In these situations, we need to distinguish the claimant from a lawful visitor to a trespasser. The lawful visitor will be governed by the 1957 Act, and my videos already talk a bit about it. Now we're going to be looking at the 1984 Act, which deals with essentially trespassers. Now, prior to the Act, occupiers could only be liable for deliberate and reckless causing of harm to the trespasser, Addy and Dumbreck, 1929. Now, this is because it was so like you had to show deliberation or recklessness, it was so harsh, the law to trespassers, that's why we saw with the children, they were dealt as lawful visitors as opposed to trespassers, using the concept of allurement. And so what was going to happen inevitably is in 1972, the case of British Railways Board and Harrington, a duty was established, a duty of common humanity as it was called, and it was to try and ease the harshness of the law to trespassers. So that's when this Act was formulated in 1984. And what it said in Section 11A is that this Act will apply to those people who are not visitors. So mainly for our purposes, trespassers and those using a right-of-way, for example in Holden and White. But note, it applies to personal injury caused to them, not to their property, as was in 1957. This is established in Section 1.8. So if we look at the case of Revel and Newbury, 1996, this guy was waiting for vandals to come on his land. They had done something before, and he shot at them, essentially, and they tried to sue for negligence. Now, the 1984 Act works same as 1957, that the danger can't arise essentially from the activities that the lawful visitor or the trespasser themselves decides to do. So, for example, in Nowen and Coventry Healthcare, NHS Trust 2006, the accident was due to climbing, not the condition of the land. And so, similarly, in the case of Revel and Newbury, the damage was to do with the shooting, what took place on the land, as opposed to any kind of existing danger on the land. So they couldn't sue for occupiers liability. They could sue under the common law of negligence. And a key thing this case also highlights is that just because you're involved in criminal activity, like they were doing burglary in this case, the people who were shot at, this doesn't make you an outlaw, i.e. the law will still help you, the civil law will help you where it's deemed to be. So with the 1984 Act, how do we put this in practice? Well, it's a twofold test. Essentially, we need to establish that the duty of care does in fact exist to a trespasser. So once you've identified that this person is a trespasser, how do you identify whether a duty was owed to this trespasser? Well, Section 1.3 says that there's three limbs to this. The first is that the defendant must be aware of the danger or have reasonable grounds to believe that there was this danger. Second, he must know or have reasonable grounds to know that the trespasser is in the vicinity of the danger or has already come into it. And the third is the risk is one in which all the circumstances of the case, the occupier may be reasonably expected to offer some protection. So they have to know about the danger, they have to essentially know about that the trespasser is coming, and they need to be able to have the capacity to offer some kind of protection. So in the case of Tomlinson and Congelton 2003, the claimant was swimming in the lake of the defendant, and basically it had ignored the no swimming sign. And prior to the accident, the defendant had thought that this is dangerous, I'm going to take some additional steps on top of this sign to do something about it, but it hadn't done so in time for this accident. And the House of Lords essentially looked at the situation and they said there was no duty because yes, okay, arguably, the defendant was aware of the danger of the first limb, but the second one, he didn't have any reasonable grounds to believe that the trespasser was in the vicinity of the danger. And also, it wasn't reasonable to expect the defendant to offer some kind of protection, as a sign was already up there, and the risk should have been one which was obvious. Similarly, in Donahue and Folkestone Properties 2003, the occupier knew the trespassers used to come in the summer, but this case happened in the winter, so he had no reason to believe or was not aware of the trespasser being in the vicinity of the danger, therefore a duty of care couldn't be established. So it's really hard to establish a duty of care. And also in White and St Albans CC 1990, they said it's not enough that a reasonable person ought to know about the danger and the likelihood of a trespasser. You need to actually look at the present situation. So long as you can establish that a duty can occur, i.e. by showing that they knew about the danger and that they knew about the trespasser and they were capable of offering some additional type of protection. What is the test? Well, the test is set out in section 1.4, which says that the duty is basically, let me find the statute, I'll just read it out to you what it says. They say the duty is to take such care as is reasonable in all the circumstances of the case, to see that the entrant does not suffer injury on the premise by reason of the danger concerned. So the key point here is the duty has to be reasonable in all the circumstances. This is different to the 1957 Act, which is just saying there is a duty. This one will take into account financial circumstances of the occupier, for instance, as identified in Ratcliffe and MacDonald. Similarly, in Platt and Liverpool's City Council 1997, to say that by erecting an 8-foot fence around a dangerous premises, the defendant did not take such care as they were required to do, it would be absurd. It has to take into account all the different factors that the defendant has already done, so it's much less onerous on the occupier themselves. Thank you for watching.